jury? According to Black Law Dictionary, jury is a body of men temporarily selected from the citizens of a particular district who do not need to have any legal knowledge and invest with power to present and indict a person for public offence or to try a question of facts. They can decide on the facts in consideration of evidence, and the judge can only guide them on the matter of facts. They can reach the decision of guilty or not guilty with a majority decisions. The judge will pass a sentence if the defendant was found guilty.
Juries trial cases in criminal courts, but occasionally they can also be used in civil matters. According to Section 7 of the Juries Act 1974, they can sit in 12 in Crown Court and High Court, and they can sit in 8 in County Court. Besides, according to Section 8 sub 2A of the Coroners Act 1988, they can sit in 7 to 11 people in the Coroner's Court. However, jurors are rarely used in criminal cases, which is about 1 to 2% only, as they are reserved for more serious cases such as murder, rape, and gravely bodily harm. Civil matters can also tried by juries such as cases of defamation, fraud, and malicious prosecution or false imprisonment. Me and my teammates will then evaluate on how fair the jury trials is in criminal cases. We divided our explanation into 3 parts. Number 1, do jurors racially stereotype the defendants? Number 2, do jurors know what to do about improper conduct in the jury room? And number 3, how the internet affect jury trials? And let's start. Will jurors racially stereotype the defendant? My answer is definitely yes. I would say that we are all actually born racist. According to an article, Are We Really Born Racist? An experiment is conducted by a psychologist, Phyllis Case, among 6-month-old infants. She first showed the baby 4 pictures of each showing a same gender and same race person, for example, 4 white women. Then, the baby started to feel bored and lost their attention in the 4th picture of the white women. Eventually, the psychologist showed a new photo of a black woman to the baby, and the baby started to regain their attention and actually looked at the black woman longer. This finding showed and supported my view that the jurors will racially stereotype the defendant. And we are actually all kinda racist inside without us even realizing it. In an article in New Law Journal of Jury Malpractice, the author said that the court are ignoring even well-founded allegations of jury malpractice to uphold a long-held principle of jury secrecy. Biased jury will violate the parties' right to a fair trial under Article 6 of European Convention on Human Rights. For example, in case R against Mirza 2004, a letter had been written by a juror to the courts after a verdict guilty had been delivered. In this case, the juror alleged that the majority of the juries had been racially prejudiced against the defendant, causing the defendant to undergo an unfair trial. And this is a clear example on juror racially stereotyping the defendant. Another example case of juror racially stereotyping the defendant is in case Sanders and the United Kingdom 2000. In this case, it is a trial for an Asian defendant, and a juror in this case complained about other jurors making racist jokes and feared that the defendant might undergo an unfair trial. With a majority of 16 to 4, the European Court of Human Rights held that there is a breach of Article 6 in the Human Rights Act. And this case clearly proven that the jurors are racially stereotyping the defendant. In an article, All Lines Signed Toward the Demise for the Jury, published in the Journal of Criminal Law, the Royal Commission research study in its sample showed that there's an overrepresentation of black jurors for about 78.6% and a marginal overrepresentation for Asian jurors for about 4.5% and an underrepresentation for Chinese jurors for about 66.7%. In addition, 65% of the sample jurors had no non-white jurors. 25% have 1 or 2 jurors. 5% had 3 jurors from a sample of white population of 95%. Other than using cases to support my views, these figures clearly show that some ethnic minority are underrepresented, and there's a huge possibility that the jurors might racially stereotype the defendant.
Improper conduct by jury refers to any violation committed by a member of the jury during the trial of a case and when a verdict has not been reached yet. These misconducts can be in various forms, such as communication between jurors and those outside of the trial. Another form of misconduct is when jurors access evidence that have not been presented to them during the trial by the judge. These evidence might lead to jurors forming biased opinions regarding the case. Thus, this may lead to them making judgments that have been affected by their newly conceived biased opinions. This jeopardizes the case and the verdict. Another form of misconduct is when jurors may conduct experiments regarding theories of the case outside of the court's presence. In order to prevent these improper conducts by jurors, the court may separate jury members or conduct questionnaire previous to the case going to trial. The punishment and retaliation for improper conduct by a juror includes, but is not limited to, being charged with contempt of the court and having to pay fines and being imprisoned for a maximum of 2 years in very, very drastic cases. Even though jury duty is well established and most citizens have a good idea of what it entails, most eligible citizens have either very little information regarding improper jury conduct or they have misinformations regarding the issue, thus preventing them from an effective performance of their duty, and in some cases making a faulty judgment. In the study of juror comprehension of judicial directions, 797 jurors at 3 courts who all saw the same stimulated trial and all heard the same exact judicial directions on the law, those jurors at Blackfriar, 69% of them, and Winchester, those in Winchester, 68% of them, felt that they were able to understand the directions given to them. But jurors in Nottingham, 51% of them to be exact, felt the directions were difficult to understand. Jurors' actual comprehension of the judge's legal directions was also examined, and over half of the jurors who perceived the judge's directions as easy to understand, only 31% of them were able to actually understand the directions fully in the legal terms used by the judge. And this percentage went down as ages of the jurors increased. But when provided with a written direction from the judge, the 31% jurors who understood these directions in legal terms, their percentage went up to 48% with written directions. Another study which involved 196 jurors in Winchester who by right should have had been instructed by a judge on improper conduct by jury due to their past experiences, acting out as jury members in the past. An alarming 48% of all jurors said that they either did not know or were uncertain what to do if something improper occurred in the jury room. Another 67% of them also felt that they should have been given more information regarding how to conduct deliberations. So in conclusion, participation in the jury system and jury duty are mandatory responsibilities of every eligible citizen, as well as being a crucial part of the criminal legal system. Therefore, understanding the core elements that may jeopardize this duty or withhold citizens from acting out their duty in the most effective manner is of utmost importance. Those citizens chosen to act as jury members on a case have to be and must be provided with simple, understandable, yet comprehensive material and tools that will make them aware of improper conduct in the jury room, and thus will be able to make the right judgment in the future.
Hello, my name is Tasim. So what do you think about internet and jurors? Is it going to affect the jury trial, like their decision making? Jurors are rarely brilliant and rarely stupid, but they are treated as both at once, said Judge Warren K. Urban. Jurors are supposed to only consider the details provided to them in court. It can affect the trial in the way when they Google or even use Facebook to do the investigation. So, to answer the question, in Columbia, Missouri, criminal defense attorney Jennifer Bukowski said that internet research affected our decision with respect to whether to keep or strike a juror. Well, can research or so-called investigation really bias the jurors? Courts and commentators have generally not given balanced appraisals of the scientific research on the effect of outside information on jury decision making. But has scientific research really demonstrated that outside research is always harmful? Well, indeed, some research suggests jurors are influenced by pretrial publicity or negative information. For example, a recent article on jury internet usage states, confidently, jurors may feel their searching is harmless and will not bias them. Something that research has demonstrated is untrue. Moreover, a close examination of the scientific evidence reveals more nuanced data than most courts and commentators have acknowledged. Researchers have found, for example, that in federal criminal case, it does not appear that highly publicized defendants are treated much differently in terms of ultimate conviction rates than the defendant who received no publicity at all. Moreover, it was low levels of publicity that resulted in greater probability of conviction. In England, In England and Wales, similar problems have arisen. In R and Karakaya 2005, a jury had found Karakaya guilty of rape and indecent assault on his 17-year-old daughter. After the verdict, a jury bailiff had found internet printouts in the jury room, including several concerning the difficulty of obtaining rape convictions. In Attorney General and Dallas 2012, Dallas, a university lecturer, was jailed 6 months for telling fellow jurors at Luton Crown Court that a defendant accused of assault had been previously charged with rape. Research in England has also found evidence of jurors using sites such as Google Earth to visit crime scene. So do you think that's relevant? Magna Carta enshrined the right for a man to be punished only pursuant to the lawful judgment of his equals. The problem posed by the internet to the administration of justice
are cogent, contemporary, and concerning, and may need to be addressed further in future.
Another factor that may have an effect on the ability of the juries to make decisions in regards to criminal cases is the advent of the internet. It goes without saying that the internet has been integrated into every facet of society, the jury included. While a trial by jury may seem appealing, it stands to reason that the internet may have a profound effect on the jury. The effect of the internet on jury decisions was brought in the light of the case of HKSAR and Chang. In this case, the point of contention that arose was regarding the jury's knowledge regarding the case. Namely, some members of the jury realized that the case was a retrial. Therefore, there was it was argued that there may have been elements of prejudice towards the appellant. Thus, the final verdict may have been the result of biasness. Another example of the case would be the case of R versus Karakaya. In this case, it was discovered that the jury had downloaded additional material pertaining to the case. It was seen. Thus, one may ponder, how should the influence of the internet on the jury be curbed? A simple yet elegant solution would be to simply ban the usage of electronic devices during court proceedings. With proper enforcement, jurors will not be able to look up information from the internet regarding any particular case, particularly if said information originates from an incredulous source. In addition, this would also curb any potential leaks regarding sensitive information of the case. For example, a juror may send a tweet regarding the case, thus revealing details of the case on a global platform. Another example of the case would be the case of R and Karakaya. In this case, it was discovered that the jury had downloaded additional material pertaining to the case. This was seen as a breach in the rule of law in two major aspects. Firstly, every party should be made aware of all evidence presented in any particular court case. Secondly, the prosecution and the defense should be granted the ability to address all material used by the jury in the process of coming to a final conclusion. Thus, by downloading additional information from the internet, this act clearly violates both tenets. Even if one were to simply overlook the rule of law, it simply does not change the fact that the jury's views are no longer impartial nor neutral. As there is no clear objective manner in which to measure the level of influence on any particular information regarding the jury, it proves the problematic nature of the internet on jury decisions. For example, a juror may send a tweet regarding the case, thus revealing the details of the case on a global platform. As such, said behavior can be controlled and eliminated. Namely, the act of sequestration may have an adverse effect on the juries themselves. An example of this situation would be to further prevent biasness from creeping in during jury trials, members of the jury should also be sequestrated. This process would involve instructing jurors to stay away from any source of information that may potentially skew their judgment in regards to any particular case. For example, jurors should avoid watching the news if the defendant is a repeated offender. As most jurors consist of laymen, they may not be able to distinguish unbiased sources from biased sources, so this is indeed for the best. It should be noted, however, that this method does have its downsides. Namely, an example of this situation would be during the Dahmer trial. The act of sequestration in this particularly brutal case had an adverse impact on the jury, as they were in need of therapy after being exposed to the gruesome images regarding the acts committed by the defendant. Thus, isolating people may not necessarily be the best course of action in the effort of pursuing a fair jury trial.
Based on me and my teammates' discussion on this topic, we can conclude that it is fair for juries to sit in criminal courts to hear cases. And based on what Sino stated just now, all the cases, the courts actually held that it is fair and there is no jury bias. Until today, the English legal system is still using jury to decide in the courts.